online. So welcome everyone to our July CAASA training. So Nats, I'm assuming you will be presenting first, is that correct?
Yes, that's correct, Tiff.
Perfect, so you are welcome to start. I think if anyone has any questions, either put it in the Q&A button or raise your hand and then I can allow you to speak. That way we can make it a little bit more interactive. So yeah, thanks to our speakers. Nats, you're welcome to proceed.
Thank you. Thanks very much. And it's a pleasure to be joining you here this frosty Friday morning. So Norman asked me to talk to you today generally about some essential commercial terms that may apply to the employer and contractors that you may come across. Obviously, a lot of you are in the construction industry already, so I'm not aiming to do anything too simple, but let's have a look and see what I came up with. So obviously, having been involved in the industry for many years, these are the clauses that I find are very important to negotiate at the beginning of the contract. And then once you've negotiated these clauses, to actually know how to implement them and make sure they are implemented. And I think as adjudicators, you may come across disputes that arise around the incorrect operation of these clauses, or perhaps amendments that have been made to these clauses that render the clauses inoperable. So I think let's start. I think just to give a little bit of an introduction in terms of the amendments to the construction contracts, which is where a lot of the issues come in, is that obviously we have our standard form construction contracts, and these are never presented to contractors by employers in their standard format. There's always amendments to the contract. So obviously for the NEC contract and the FIDIC contract, you would require certain amendments to bring it within the South African legislative requirements or based on South African common law. So there would be amendments to the contract on that basis. However, that employers generally further make additional amendments to the contract that shift the risk profile. So I think when you look at a set of particular conditions, we call them particular or special conditions to each of the standard form contracts, and you see an amendment, it's important to try and understand why the amendment was made and what the impact would have on the contract. So generally the bespoke terms and conditions are not used. You do come across bespoke terms and conditions. These would be developed by the employer, or usually their attorneys. Just one of the things that I have noticed is that when there are bespoke contracts that a particular employer does use, a lot of the time, you'll find that he has employed various legal advisors over the years, and these legal advisors come from different places, and they take the standard form contracts and they chop and change it. They add clauses that they've come across before in their lives. So generally those bespoke contracts are pretty much a mishmash of a lot of different clauses lumped together, which generally looks quite bad for the contractor. So as an employer, you need to realize if you're going to be using a bespoke contract, that this may be an issue. And then as a contractor as well, just to understand some of the history behind how that contract was formulated. And they do often weigh very heavily in the employer's favor. Yeah, I'm sure you all know what I'm talking about. So these differ from the standard form contracts in that the standard form contract, you buy the book, and then the book has the terms and conditions already printed into it. And then you have your contract data or your appendix to tender, which is your commercials. And then you have your particular conditions, which then amend the standard form contract. But the nice base is that standard form contract is pretty balanced in terms of risk. And those particular conditions will seek to adjust that risk. Yeah, so I think that's just an introduction in terms of where my discussion on the various clauses is going to come from. Okay, so these clauses referring to dates often cause quite a lot of confusion. So from my perspective, just in terms of some of the issues that I've come across is when we receive a tender as a contractor, we obviously submit the tender on the basis of the instructions to tenderers. And that instruction to tenderers may say that the contract will come into force. I've seen some of them say when the contractor receives back one signed copy of the contract. So that's meaning when the actual agreement comes into effect between the parties, and there's rights and obligations that are set out in that contract. So it's quite important to understand when you're a contractor tendering for the works, how and when this contract becomes effective. For example, the JBCC contract, it just says the contract becomes effective when there's been an offer and acceptance. Doesn't refer to the signing of the contract. So when the contractor receives a letter of acceptance to his tender, that means the contract has become effective, and that would then be the effective date of the contract. Then we have a signature date. What is that? So the signature date is often the date that the parties, the date the parties sign the contract, but that may not actually be the same as the effective date. So there may be a pre-existing effective date, there may be an effective date that comes into the future. Then the next date that I come across is the commencement date. This is when does the work actually start. So when you look at the date timeline, I always like to draw like a little line in the schedule to say, when does it come into effect? When is it signed? And when do we actually have to commence the work? Because there may be three different dates. And as you know, the commencement date of the works is generally the date that starts the time for completion. And then if you don't complete within that time for completion, then you have penalties and other issues that arise. So yeah, just some tips in terms of the dates. If you do see a lot of dates mentioned in the contract and you're not too sure, where's the site access date as well, where was the signature date, when's the contract coming to effect, just draw the timeline and make sure that you're comfortable with all of the dates and what they mean. Then another date that you come across a lot, and we do see it amended a lot, is the definition of a base date. So a lot of people are under the impression that the base date only applies to your contract price adjustment, but it actually doesn't. So for example, in your FIDIC contract, it says in the change in law clause that if any changes to the law occur after the base date. So the base date in the FIDIC is 28 days prior to the submission of the tender. So when you do see a base date, don't think it only applies to the CPA clauses. It may be applicable to other times within the contract as well. Okay, the dates are interesting. You do come across issues with the dates, but yeah, just takes a bit of time to understand the time frame and the timeline. Okay, the next one that I thought is often overlooked, unless you've had some experience in an issue with the priority of documents. You'll see some of the contracts do have it. For example, the FIDIC has it at 1.5. It has the priority of documents, and it'll say, that's ranked in the order of precedence. There's number 1, number 2, number 3, number 4, number 5, etc. What happens often is that 2 of the documents say different things. So, for example, of a type of specification, and then there's a dispute that arises in terms of which one applies. So the priority of documents simply means that the documents that are ranked higher on the list, where they are listed in the contract, when they are interpreted, will take precedence over the lower ones. So if, for example, you as a contractor, you have negotiated special conditions, but you see that in the precedence or priority of documents, your special conditions are ranked lower than the general conditions, that wouldn't make sense, because you would want your negotiated terms to rank high in the order of precedence to the general conditions. So yeah, be very aware of that clause. And basically, when you see priority or precedence of documents, that's what it means. The higher in the list, the more important it is. Okay. Remember as well that this only occurs when there is actually a discrepancy between the documents. If there's no discrepancy between the documents, then obviously you're not going to have to use this clause. All right. The next clause also often overlooked, unless you've had issues with it, is the communications clause, and how do we communicate under the contracts. So obviously communication can take various forms. There'll be instructions issued, there'll be notices that are served, there'll be other forms of general communication, certificates being issued, those kind of things. So as a contractor and an employer, we want to understand how we communicate under this contract and which communications may be binding on the parties. So in for example, your FIDIC contract, it has clause 1.3 that talks about how we communicate. And it says it'll be sent to the respective addresses in the appendix to tender, and there may be an email address as well, which means that we can communicate via email. You'll see in the JBCC contract, it has a couple of extra provisions that say that when we deliver by hand, it'll be deemed to have been received on the day that it's delivered. It'll say that when we've emailed it, it'll be deemed to be received the first morning after, whatever. I mean, the contract says many things, but that would be important when you're as an adjudicator as well, because obviously the notice periods in the contract specify that JBCC will say your notice of claim has to be submitted within 20 working days. So what are 20 working days? And what does it mean by submitted? Submitted will be when it's received by the party. So if you submit it on day 20, but the contract actually says that if it's an email, it's deemed received the following day, you may be out of time. So then you may be time barred. So very important to understand how we communicate when it's deemed to be received. Be very careful of these clauses, particularly because of the time bar clause. Another issue that you find is that there's communication via WhatsApp. So people develop these project WhatsApp groups and then they WhatsApp each other. And a lot of the contracts say that it will be in writing, or communication will be in writing if it's in a printable form, capable of being copied. So obviously we've got screenshots on WhatsApp. So would that actually be a communication under the contract? And for example, the JBCC have actually recognized that in their latest version of the contracts, they exclude social media from being a form of communication. So I think that they developed that particular clause based on issues that they'd had in the past around whether a WhatsApp message could be an instruction from a principal agent, for example. You know, what is the actual contractual bearing of that WhatsApp message? So be very aware of that. Know, as an employer, contractor, if you're acting as the engineer or the principal agent, exactly how we communicate under the contract. Make sure your notices are submitted to the correct addresses, and also the timing for their delivery. Make sure that if you are one of those that likes to leave things to the last minute, that you understand that if today is the last day, I need to deliver it by hand, because that is the only method of communication that would be received on the day that I'm actually sending it. So yeah, just be aware of those things. A couple of issues have arisen with the communications clause. Okay, another one that you often see is the assignment clause. This is not necessarily a high risk clause per se, but it's just something that I find I get a lot of questions about, and a lot of issues arise out of it, and it's always amended. And so the standard assignment clause always says that, you know, the parties may cede and delegate the contracts on consent of the other party. So what does that mean? All it means is that we are taking the rights and obligation under the contract, and we're shifting them over to somebody else. So now the reason why people don't like that is because they don't want to end up in bed with a contractor or an employer that they haven't vetted. They don't know who they are. So there's generally restrictions around the assignment clause. And that's the reason for that. So heavily negotiated, not often that you come across it, but when you do see it, just know that is the purpose of that clause, is to make sure that we understand exactly who we're contracting with, and that these rights and obligations can't be transferred to a third party, and that we don't know who they are. Okay, so the next clauses in a contract that are also amended are the breach provisions. So what is a breach provision? So if one of the parties fails to perform under the contract, the other party would be able to issue a notification to him to say, you have failed to perform this obligation. So now in all of the standard form contracts, these breach provisions contain very strict timelines and notice requirements in order to get into the remedy for a breach. So I find a lot of clients, they come to me and they say, oh, they're in breach, we want to terminate the contract tomorrow. You know, I can't stand him anymore, I want out. And I say, well, you can't do that, because that's not what the contract says. The contract says you first have to issue a notice outlining the breach. You then have to give them an opportunity, 14 days, whatever it might be, to remedy that breach. And only should they fail to remedy that breach, then you may invoke the termination provisions. So there may be a claim by one of the parties for a wrongful termination or a repudiation of the contract. And what that means is that the party that does wrongfully terminate or repudiate the contract may be in for a damages claim for the wrongful termination. So we want to try and avoid that. So the breach provisions in the contracts are always very clear in terms of the processes and procedures that need to be followed in order to get the remedy in accordance with the breach. The breach provisions even may relate to, for example, late payments. So if we paid late, the employer is in breach. How do we access the remedy under the contract due to that breach? That is one that is often deleted. So the waiver of the lien the deletion of the right to suspend the work when the employer is in breach of the payment provisions. So yes, breach provisions in the contract, follow them, make sure that they're fair. So for example, if you're the contractor, doesn't say that the employer can give you 24 hours notice to remedy the breach, otherwise he can terminate the contract. That's a bit unreasonable. So just make sure that you understand exactly what you can do if the employer fails or if the contractor fails in terms of their obligations under the contract. Just on that topic there about the remedies being contained in the contract, there's also remedies at common law. Obviously, South Africa is a common law legal system. So just because it's not, something's not listed in the contract doesn't mean that it's not available. So often you'll find if the employer has a bespoke contract, he doesn't have any remedies for the contractor should the employer breach the contract. He deletes them or he doesn't draft them into the contract. That doesn't take away your rights. What you can do is you have to place someone in mora. So in mora, it's some Latin phrase, but it means that you then have to actually place them in breach, and you have to give them a reasonable time within which to remedy the breach. And if they fail to remedy that breach, then you may terminate the contract. That might not be in the contract, but it's still there. So yeah, breach provisions, very important. What are our remedies when one of the parties fails to perform its obligations under the contract? Okay, my favorite, the deeming provisions. Everyone wants a deeming provision because it's so simple. But what is a deeming provision? I'm sure you've come across them a lot. So basically what it means is that if a certain specified circumstance presents itself, then the obligation gets created. So I've given you some examples because it's a little bit difficult to explain as well to the layperson. And the contractor shall be deemed to have satisfied himself as to the correctness and sufficiency of the contract price. You find that in your FIDIC contract, for example. That means that when he enters into the contract, it is deemed that he has satisfied himself, and he cannot then come back and say the contract price is incorrect for whatever reason. Another one is, you'll see this as well in some of the contracts, if the employer is invited to attend the test on completion, for example, and if the employer does not attend the test on completion, or the engineer, whoever it might be, those tests will be deemed to have been done in the presence of the employer and will be taken as accurate. That is a very expensive deeming provision for the employer. I came across this yesterday in a negotiation, and the employer, this was the contractor suggesting this. Obviously, he didn't want, instead of having an extension of time that he would normally have for a failure by the employer to attend to the tests. I'm using employee here because this was a FIDIC silver book, and obviously there's an employer's representative, but in your FIDIC red and yellow, you would have your engineer who would need to attend to the tests. And the general remedy would be an extension of time for failing to attend to the tests within the time limits specified in the contract, and the contractor wanted a deeming provision. That means that if the engineer or employer doesn't attend the tests are correct. Very dangerous to the employer. So check out for these deeming provisions. The contractors do like to add them. I haven't seen so many being added by employers. I think it's just a nice protection that the contractor thinks he's getting a protection for failure to act by the engineer, but there are actually other remedies in the contract besides the deeming provisions. Okay, the defects liability obligations. So this one also may form the basis of disputes. Because the parties aren't too clear on when the defects liability obligations commence and when they cease. So I think it's very important that the contract must specify that. For example, the FIDIC does say that the defects notification period will commence on the dates notified in the taking over certificates. But this might get confusing when there's sectional completion. And the employer is of the view that the defects liability of 365 days or whatever it is might commence on the date of issue of the final taking over certificate, but the contractor is of the view that each taking over certificate or each section will have its own 12 months defects liability period. So I think, you know, in terms of that's the one example that I can think of where issues have been created. In terms of when it starts and when it ends. Also, just a quick discussion on patent versus latent. So latent defects are not defined in South African law. In other words, it doesn't say that for this specific item of work, there will be a 5-year latent defects liability period. For example, in your codified legal systems, it'll say that for civil works, it must be 10 years, for mechanical works, it must be 8 years or whatever. So the latent defects liability period is actually specified. So you'll see, for example, in the JBCC, we have a latent defects liability period of 5 years, but you don't see it in the FIDIC. And I think the reason is that it's brought into the South African contracts because we know in our legal system that it has to be defined in order for it to have some kind of certainty on its effect. We do find latent defects liability periods added into the standard form contracts, the international standard form contracts, and just understand that that is the reason behind that. And patent versus latent, that is just a legal term. Patent means that it was visible with the eye upon the reasonable inspection, and latent means that it was there at the time of the inspection, but it was not visible to the eye. So that's the difference between the two. So your latent defects would manifest themselves after the inspection has happened, after the defects liability period has been completed. Then there was something that was there at the time, but it wasn't something that was seen by the eye. That's the difference between those two. And then obviously important is the duration of each of the obligations. And then also, how do we extend these obligations? So you'll know the standard FIDIC clause has, in terms of clause 2.5, you can claim for an extension, the employer can claim for an extension of the defects notification period, and you can do that for a maximum of 2 years. And the extension is based on the time that the works could not be used. So you sometimes see that clause adjusted as well. They change the maximum 2-year extension period to 5-year extension period. So the contractor knows that he has these defects liability obligations potentially for 5 years after he's achieved taking over of the works. So yes, that's defects liability obligations. I think from my perspective, some of the issues that I've seen is on claims for latent defects or patent defects is that the defect, the definition of a defect is generally found within the contract, and anything that goes wrong with the works after taking over or after practical completion, the employer will obviously look to the contractor to remedy those defects. But a defect has a specific application in the contract, and it must be failing to comply with the specification, for example. So the contractor, even though a defects notice has been issued by the employer for the contractor to remedy the defect, the contractor would always have a defense to that claim to say it is not a defect, the works was executed in accordance with the specification, therefore we are not remedying at our cost. So there's all those remedies available to the contractor. I've had guys as well, they've come and said, no, 5 years after they've handed over the work, there was this latent defect, claim for a latent defect. And I'd simply say to them, request the maintenance schedules for that particular piece of equipment. And obviously the employer couldn't provide those maintenance schedules. So we had a nice defense to the latent defect claim to say that it's not a latent defect, it was not maintained correctly in accordance with the operation and maintenance manuals. So I think from that perspective, as an employer, you need to make sure that if you have defects liability and latent defects liability periods, and then there's requirements in terms of operations and maintenance, that if you expect your contractor to come back and fix his mistakes, that you have to on your side also comply with your maintenance and operations obligations. I think I see is there something in the Q&A, Tiff? Okay, this Earvault. Earvault asks, if contractor does not submit a program of works, is there other ways that he'll be able to prove critical path to claim extension of time? If he does not submit a program of works, is there any other way that he will be able to prove critical path to claim extension of time? I'm not sure what you mean. If there's no program of work, how would you map the critical path? So I don't think my initial answer is going to be no to that. And remember that if he fails to submit a program of works, how would he ever justify a claim in any event? So especially, for example, in your JBCC contract, your extension of time claims have to show the impacts to the critical path. I'm not sure if that answered your question, Evolt, but if you want to expand on that, you're welcome to do so, and I'll have a look a little bit later at the Q&A again. Okay, so that's your defects liability obligations. The next one, oh, not working, just give me a sec. Oh, there we go. Favorites, force majeure. So, all of a sudden after COVID, everyone became aware of what the force majeure clause was. So I thought it might be fitting just to mention it in this discussion as being quite a critical clause, because before everyone ignored it. And now I've never had so many people asking me questions about what does it mean and what are my rights and what do I get when I'm standing, those kind of things. So very important clause. And just as some background, it's not actually a recognized term in South African law. It's not something that's defined in the legislation or codified like it might be overseas. In Brazil, I know, for example, they have an actual codified definition, legal definition of what force majeure is, so that if you see the word force majeure in a contract, you can refer back to that particular piece of legislation or code. And in the contracts in South Africa, we actually have to define what force majeure is. So in the definition section, it'll say force majeure is an event which neither party could have prevented, was not foreseeable. You've seen all of those kind of definitions. And the reason why those definitions are there is because that is where we go to look, to tick all the boxes as to where that particular event that occurs is a force majeure event. So what does it mean when there's a force majeure event? All that the contracts say is that when parties have rights and obligations, the contractor has an obligation to complete the work. The employer has an obligation to provide access to site to the contractor. So we have these obligations. All that it says is that if you can tick the boxes of a force majeure event, that those obligations are suspended. In other words, I, as the employer, can't hold you accountable and issue a breach notice for failure to perform because you can't perform during this event. On the other hand, the contractor can't say you're in breach of contract because you haven't given me access. So all it's doing is it's almost like taking a time block to say that during the period that one of us is affected by this force majeure event, neither of us can hold each other liable for our obligations under the contract. And that's all that it's doing, really. So now we get the question, okay, so now that we can't perform our obligations under the contract, how do we deal with that bubble of time where neither of us could perform, or I couldn't perform, or you couldn't perform? And that's generally the contract will then specify how we deal with that. So it is a no fault. It's a no fault clause. No fault means that it's not the fault of the employer and it's not the fault of the contractor. So the no fault clause will generally either be entitled only to an extension of time. Perhaps in some instances, the employer may agree to pay you certain costs during that time period. So the issues with COVID that arose was that, I think the first impacts that we started having from that was when, as South Africa, we couldn't receive goods because of the shutdowns in China and things like that. The shutdowns hadn't come to us yet. So then failing, there would be an issue with not being able to receive or procure items that would be delayed in the ports or in the factories or whatever it was. So that was the first instance of the force majeure that we felt in South Africa. And then obviously it extended when it came to March to be that piece of legislation that was promulgated to deal with the state of disaster. So, and then that shut down the site. So it's almost like when we had that event, we're saying, well, we have to tick the boxes. So we had to go into each contract and say, all right, so in this contract, would it be a force majeure event? Because this is how it's defined. Can we tick these boxes? Right. Once we've ticked the boxes, what do we have to do? So we have to issue a notice. When do we have to issue this notice? Okay, within 14 days of the event occurring or whatever the case might be. So then we have to tick that box. And only once we tick that box do we then have our obligations suspended. So yeah, the process would be in the definition of the force majeure, the process, and then they'll say, right, what are our rights now that we're in this bubble of time? So for example, the JBCC defines force majeure, but where is it? It's in the clause that says you only get an extension of time and no costs. Doesn't help anybody, poor contractors. They were like, how do we claim? How do we claim? I'm like, well, you can't, there is no ability in the contract for you to claim due to a force majeure event to claim your costs. So I think that's also why people started becoming a bit more aware of this clause, because it did have a severe impact. I think a lot of the employers were sympathetic with their contractors and you know, agreed to pay them a small standing time amount just to make sure they could pay their staff, for example. But I mean, it's not a contractual obligation. And then in the FIDIC contract, you also have your force majeure. You have to tick all of the boxes for the FIDIC contract. Can I tick all those boxes? And then it'll be a force majeure event. I issue the notice. And then some of the force majeure events, I only get time. And then others, for example, if it's strikes or riots, then you get within the country being South Africa, if you executing the works in South Africa, then you would get a cost entitlement as well. So yeah, I think the point is that force majeure has to be written into the contract. And as employers and as contractors, we both need to understand the impact that it's going to have on both of us when we read this force majeure clause. The employer, he says, well, I can't produce, you know, while I can't produce coal, let's say, while the force majeure event is occurring. So why should I pay you your standing time? You know, and they have this like backwards and forwards. And the best time to actually negotiate this clause is at the beginning of the contract, because nobody wants to take this risk. Employer doesn't want to pay, contractor doesn't want to take a claim for extension of time with no cost, and it ends up being quite a hectic deadlock. So then you can find the balance. You say, for the first 30 days, I won't pay you, but then if it goes on between 30 and 90 days, then I'll pay you. And at 90 days, I can terminate the contract, because then my obligation to pay you ceases. So yeah, various ways in which we can deal with force majeure. A very interesting one, very, very critical. A force majeure event may not occur during the contract, but I think that since COVID, like I say, everyone's become a lot more concerned and worried about this clause. I just see there's another Q&A. Eva, a defect occurs just before expiry of the defect's liability period. Valid maintenance done. Does prescription then apply to that defect? Prescription, okay, so prescription meaning the extension you're talking about. That I'm not too sure. I wish we could talk. I mean, can we have people talking on this thing, Tiff? I think it would just be a lot easier if we could have a discussion.
Anyone does have a question, they can put up their hand and then I can allow them to talk.
Yeah, I think if I would actually like him to just explain, you know, this one a little bit more, because prescription for me in a legal term is your, you know, in terms of the Prescription Act. So I just want to, I think Uwe, you may speak.
Okay, Uwe, I've allowed you to speak if you'd like to.
Okay, can you hear me?
Yes.
Yes, thank you.
Okay. So whatever the defect is has occurred, and it's just before the end of the defect's liability period. Does that mean, and everything was done, so it's okay? Now, if that same thing were to fail again after the expiry of the defect's liability period, is the contractor still responsible for fixing that particular defect again?
Yeah, I think so. So on that, so the defects, the contracts generally say, they'll specify that the contractor's remedy is obliged to remedy defects that occur during the defect's liability period. So if that defect had to occur just before the expiry, yes, there would be an obligation to fix. What then would have to happen is that the employer would have to use the mechanisms in the contract to then extend the defect's liability period for the period that he was unable to use that particular portion of the works due to the defect. And if he doesn't do that, that would then fall away. So that's why they allow for that extension of the defect's liability period. And it's limited only to the time frame that you couldn't actually use the work based on that defect. So the employer should apply for that extension.
Yeah, that I think is a difficult thing that employers probably don't realize that.
Yeah, they probably. Yeah, well, exactly. So the thing is, I mean, if the way the FIDIC does it is quite nice, is that it specifies the process, and then there's a claim that's made by the employer, and he can then extend that defects notification period. So, yeah.
Thank you very much.
Yeah, I don't know if Eelwald wants to talk. I mean, I know you had a question about if there's no program, then how do they prove the critical part? I don't know if there's anything that came from that, but I assume we're good with that one. Okay, thanks, guys.
Speak, Eelwald, if you'd like to. Okay, I don't see a response, Nat, so maybe we can go back
Yeah,
to that.
okay. No problem. I think it's much better. I like the talking. So if anyone has a question, let's get you on and let's talk through it. Okay, so those indemnities? So these indemnity clauses are also quite interesting because they're all quite different. You'll see the indemnities clause in clause 9 in the JVCC, it's in clause 17 of the FIDIC. They're all in different places in the construction contract. What does it mean? All it means is that if I am going to be responsible for a claim to someone, that you, as the contractor, for example, agree to step in and take responsibility for that claim. So it's almost like if you're the indemnified party, you take no responsibility for it, and the indemnifying party takes responsibility for it. I think that's the simplest way that I can explain the indemnity clause. It's often difficult to escape the indemnities clause because I think the parties feel quite strongly in terms of what risks they're willing to take as a party under the contract, and any of these apples that fall outside of my risk basket, you must take. But yeah, so I just want to talk about one or two very interesting indemnities that I found in the contracts. The one being under the JVCC contract. There's an indemnity that the employer gives to the contractor for loss or damage to an existing structure and the content of that structure. So that indemnity means that even if the contractor causes that loss, if there is a loss to an existing structure, obviously the works has got to be for some kind of adjustment to the existing structure. That if the contractor does cause a loss to the existing structure, the employer has said, I'm indemnifying you, so I'm going to step into your shoes and take responsibility for that loss. And I think there was one of those macros that burnt down. I don't know if it was the macro there in Woodmead or where it was, and what happened was the contractor was doing alterations to, in a small corner of that warehouse, and a spark flew off due to a negligence of one of his workers and things like that, and the whole place burnt down. And I think when the insurance companies were batting it out, the courts actually held that indemnity in the JVCC is so strong that whether the contractors are negligent or not, the employer takes the risk in loss or damage to that structure. So that's not found in your other standard forms of contract. So I think when you come across an indemnity for loss or damage to existing structure, just understand that that's the basis for that indemnity. And as contractors, we always like to say, look, I'm coming in, this is a brownfields project, I'm coming in to do a piece of work in a small portion of this massive, facility. I don't want to be responsible for, the loss or damage to your facility. I only want to be responsible for my work. And you as the employer need to make sure that you have the correct cover and insurances, etc., in order to give me comfort that I'm not going to be held liable for any losses outside of the works that I'm performing. So that's one interesting indemnity that I thought gives quite a good example of what indemnities are. They're very strong, they're recognized by the courts. So when you read an indemnities clause, and they're very long, sometimes they're like 10 lines long, and you get very lost trying to read exactly what you're indemnifying who against. It's just to break it up and to say, right, I'm indemnifying the employer against these things. Okay, so I'm indemnifying the employer against death or injury to a person. That's one of them. That's generally an indemnification as a result of my actions. Okay, I think that's fair, because I can't expect the employer to be responsible if I kill somebody and there's a claim from the family or whatever it is. So then I need to make sure as the contractor that I have sufficient third-party insurance to cover any of those losses. Another one that we come across is the contractor indemnifies the employer against any loss or damage due to a breach of the law. That's also something to say, well, look, me as the contractor, can I expect the employer to take responsibility or risk in my breaches of the law? Probably not. Okay, I'm willing to accept. So if anything happens or anyone claims against the employer or something happens because of my breach of the legislation, I'm going to step in and take that responsibility. Another one you see often is a breach of a third party's intellectual property right. So as the contractor, I'm expected to take full responsibility that once the employer is using my plant or my piece of equipment or whatever it is, that he's not going to come and get a claim from someone to say you are infringing my intellectual property rights. I'm going to say, as the contractor, I'm going to step in and take that obligation. So those are some of the ones that I can think of that are generally the full indemnities under the contract. In the bespoke contracts and some of the amended contracts too, you find in, the indemnities clause is clause 7, but in clause 4 and then in clause 6 and then in clause 32, they've got the contractor indemnifies the employer against any claims for a breach of this clause. So be very, very careful of that. From an employer perspective, what you're doing is you're telling the contractor that he needs to make provision in his price to take that risk on. And from a contractor's perspective, if you miss those indemnities, you're never going to be able to say, I'm willing to contract on this basis, taking these risks, and I'm going to add this premium to my price to take those risks. So it's much better if the indemnities are all packaged in one nice little bundle, like they are in the FIDIC. But some of the other contracts, especially when some lawyers get hold of it and they want to try and exclude all risk for the employer, they just simply litter the contract full of these indemnities. So very, very, very important. What I like to do actually is when I get a bespoke contract, even get a set of particular conditions, I actually do a search and I look for the word indemnity, indemnify, and I just to see if they've added any somewhere in the specifications, in the employer's requirements, in the scope of work, somewhere that they've added this added indemnity, because it's a very severe clause for a party to take on an indemnity if they don't understand the implications of it. Okay, so yes, and these when we're talking about a limitation of liability, which is what we're going to talk about next, these indemnities are usually carved out of that limitation, which means that if we have a bundle of risk that we're willing to take as the contractor, which is say 100% of the contract price, which is the general trend or the standard in terms of the FIDIC, any claims that surrounding the indemnities don't fall within that limitation of liability. That's extra. Okay, so indemnities are normally carved out of the limitation. Understand how they're carved out. If you do come across if you do have a claim, if you, as an adjudicator, you come across an issue with the indemnities and the limitation, you can see and obviously how they're carved out. Are they forming part of that limitation? Because the contract will specify what those limitations are on those carve-outs. Okay. So now we're going to
questions on this section. So
okay.
I'm just going to allow Mike to speak first.
Sure. Hi, Mike.
Hi, sorry. I've been taught to deal with indemnities with extreme circumspection. And on that basis, there are two questions I'd like to frame. One, indemnities are normally associated with taking over liability for loss.
Yes.
But what happens when the indemnifier challenges the loss of the third party? Where does what is the position of the indemnified? Because the indemnifier only comes into play if the indemnified has some obligation to make up a loss. But that loss hasn't been incurred, the indemnifier has no obligation. And does the obligation to refund the expense or the liability for the loss occur after payment or before payment? And then the last bit is, what happens if the indemnifier is insolvent? Where does that leave the indemnified?
Yeah, those are some good questions. So obviously a claim could only be had by one party to another based on a cause of action. Okay, so if the contractor who is the indemnifier, okay, has caused the loss, then there's a direct link between the person who suffered the loss to the contractor. If the employer, for example, caused the loss, and I'm talking that link is a common law link, a common law link because of causation. If the employer has caused the loss, but there's an indemnity provided by the contractor in terms of that loss, then the third party who has the claim would only have a claim against the indemnified, okay, because there's no tie to the indemnifier. And then the indemnified would have to seek recourse from the indemnifier. If the indemnifier has no money, then the indemnified ends up taking the loss. So there's no certainty. And I mean, there's no certainty when we do business that the person that we've said we're going to have a claim against was going to pay something has the actual funds to pay it. You know, so that's the risk that you take. So when I'm saying, yes, the contractor has indemnified me against all of these things that occur when I'm getting claimed on, you know, we can't control, you know, his balance sheet. And we need to be aware of that when we feel in our comfort zone. We feel comfortable because we have someone else indemnifying us, you know, and that comfort could be false. So I think that also in some instances the contract might deal with it as well. So, for example, I know in the intellectual property clause, it'll say that if the employer has a claim from a third party for a breach of intellectual property rights, the contractor has to step in, you know, and take over that responsibility. And then there's like steps and procedures on how that would apply. But from a common law perspective, if there is a causation element where the loss is caused by the contractor, then there would be a direct link between the loss sufferer and the contractor. The employer would simply say, I'm indemnified under my contract, seek your remedy from the person that caused the loss. If there's no link, then it would have to be a contractual claim with no guarantee of success, unfortunately, if there's no money.
Nats, there's Yas also has his hand up. I'm just going to allow him to speak.
Yeah, also, I don't know if Michelle wants to maybe add something there as well. She's a lot more, should I say, book smart than me. But yeah, can I see if Michelle first wants to add something to the discussion around the indemnities that might be useful?
Yeah.
Nothing at present, Nats. You've got it.
Okay, good. That makes me feel much better on this wonderful Friday. Thank you, Michelle.
Okay, yes, you're welcome to ask your question.
I appreciate, just for clarity to answer, the business that we're in, we work with the construction mafia, so we assist the companies with the construction mafias, and not just construction, various companies, because it's in various fields. But if a client, this is my clients, they sit with this problem. So their client, if they are aware of this type of liability that can cause a loss, but in the contract they intentionally make it that it's not their problem. Is that correct? Is that a fair practice? Do they have the right to do that?
Yeah, I think that, you know, we do find that a lot of the employers try to say, I'm wiping my hands of the construction mafia and use the contractor must take that risk. And I think that whether it's fair or not, nobody cares, to be honest, because what does the contract say? And if there's any disputes or there's any issues around the impact that the construction mafia have had on the contract, your answer is going to be in the contract. And if your client or a contractor has signed a contract where they've taken on that risk, it's going to be very difficult for them to say, but it's not fair. Okay, so
I'm talking about pre-setup, before you do the contract or anything. So now I'm sitting with the main developer, and with the main developer, I'm making him aware of what is the threat possibility of the site. So in that essence, looking at it, I mean, if you sell a house when you know there's a defect on the house and you don't report it, then you are liable. Now, the same is what I say is when you have a contract that you're putting out for somebody to tender for, they are forcing the contracting companies to come in at a low rate, ignore the definite liability even before the contract. So you get what you call the project quantity survey should actually include costs into the project cost, but it is nobody's trained in that. So what we're trying to get to the main developers, companies, and investors, banks in the district, come and see to say, listen, yeah, there is, it's not a maybe, it's 100% threat assessment it's there. So preparation need to be in it, even when you are preparing a tender for that.
Correct. And I think that you need to make a decision in terms of who's going to carry that risk, should a risk event occur of that nature. And what are we going to do about it? So some of the contracts have gone so far as to say, right, this is going to be a shared risk now because neither of us can really control it. We're doing what we can, but if the construction mafia come to site and they blockade the site, this is what we're going to do. You, the contractor, are going to go to the police. Then after you go to the police, you're going to go to the court and you're going to get an interdict. So I don't know, I mean, so they're starting to set out these procedures to deal with the issues. And it's working quite well. And I think the reason it's working is because the parties understand what their relevant obligations are, and they've discussed it beforehand, and they've agreed as a unified entity, you know, to collaborate and cooperate and do what they can from a legal perspective to make sure that these instances are minimized and how they are dealt with. And then also they'll go even further to say that if one of these instances occur, how do we deal with the time and the cost risk, you know, from a project perspective, and they reach a balance. And I think doing it that way creates that more collaborative working relationship. When the employer simply says, listen, I'm aware, we all know that it's here, but I'm not taking any risk. He's not helping the situation, you know.
Yes.
The contractor is going to add $1 million, you know, onto his price to say, well, let's see, I've added on $1 million to, you know, for 2 months delays. You know, this is going to break, that's good, they're going to throw a bomb here, they're going to, you know, whatever. So he has to now add it on his price. And then if it occurs, he's like, okay, well, it's fine, I've actually made provision for it, you know. But I mean, those kind of discussions need to be had at tender stage, and there are ways of dealing with it. I just think it's difficult to put that specific instance into a force majeure, for example, because from the definition of force majeure, it says it was so unreasonably likely to happen, you know, and that doesn't tick that box. So we can't even use the force majeure. So what are we doing? So this construction mafia has created a bit of a wave, and the wave is, you know, people are riding the wave in different ways. Someone's saying, I'm closing, you know, hear no evil, speak no whatever. And others are dealing with it constructively, and that's what we need to do.
Yeah, no, we're quite on our legal side department. We've got it managed quite right. We've got a lot of companies that are starting, developers that are starting to buy into this concept.
Yeah.
But I need to know just from your side, like I say, is there an act that's something in the act where it would say that if I have a developer and he's aware that, I mean, commonly aware that there is this situation, that it needs to be referred in the contract. It cannot be, you know, it needs to be in the document, in a tender application, specified. Is that a necessity?
There's no law that requires that. Remember that as the contracting entity or the tendering entity, you have the ability to investigate, to see the site, to, you know, to do those kind of things. And generally you need to take into consideration, you know, the area where it is, the surrounding communities. I mean, you know that as a prudent contractor, and if you both the employees keeping quiet and the contractors keeping quiet, it's a recipe for disaster. So if you receive a tender document, that's something that you would have to qualify. So you would say, listen, I'm submitting my tender, but I'm making these qualifications. One of them being, you've provided no information on the surrounding communities. We could not access the surrounding communities to figure out who the chief is or the CLO or whatever it is, you know, and we would require the ability to do that. And if there's a change to our proposal based on this, then we want to be able to get additional time or additional money. So you would actually put it in your tender proposal as the contractor if the employer hadn't dealt with it. You can't, there's no law that says, oh, he's doing something illegal because he's not mentioning something in a tender. It's not the same as a defect. It's not the same. It's not dealt with in the same way, if that makes sense. Like you're talking about the house. It's not, you know, defect in the house if he doesn't disclose it. That's different. This is, you can't do that, you know, contractually. There's no law against it.
Appreciate it.
Okay, all good. The construction mafia, it's lovely to talk about them on a Friday. Okay. Okay, so those are the indemnities. So yeah, very careful of those. The limitation of liability, the limitation of liability, I like to split it up because I think it has a couple of elements to it. So what it's saying is that there's a cap, a monetary cap. So there's always like in terms of what is my total liability in terms of money under this contract. So it will either be a monetary amount, all right, or it'll be the contract price. That's the one that you see in the standard FIDIC, for example. You'll see the contract price or accepted contract amount or whatever it is that you've agreed to. So what does that actually mean? Okay, let me just go back here. So that means that no matter what happens under the contract, breach of contract, damage, destruction to the work, whatever it might be, I, as the contractor, am not going to be responsible to pay you any more than the contract price. Okay. And that's our limit of liability. So I've got some clients, for example, that say, listen, they're very risk averse. I don't know why. I don't know what they've done wrong in their lives, but they're like, no, we are not executing this project unless we get a 10% cap on liability. And that's it. They won't, they refuse. So if the employer wants to employ them, their cap is 10% liability and they are not budging. And they get it right. So I think it depends on your risk appetite. That was more on a plant design and build type of contract as well. So each of the contracts are different. But basically what we're saying as a business is that I'm not exposing myself to more than this cap. Okay, so the monetary value, cash cap. Okay. Then there's also another part to a limitation, and that's an exclusion of consequential loss. So consequential loss is things like loss of profits, loss of contract. So if I breach the contract and because I breached the contract, you have now can't function 3 of your other plants and you've lost 200 million Rand in profits per day, that's excluded from our liability. So no consequential loss. And this is sometimes not negotiable for a lot of companies. They refuse to be responsible or liable for consequential loss. Okay, so you always see that. And then there'll always be the carve-outs from that limitation. So we spoke earlier about the indemnities, where you have, you give specific indemnities, and these indemnities are carved out. Remember we spoke about that bundle. This is now the cash value that we limited to in terms of our exposure under this contract. Carve-outs mean that they're excluded from that cap. So the cap will be responsible for the cap plus. Okay, so we need to be careful. What are the carve-outs from the limitation? Okay, the general carve-outs that you find from a limitation is breach of warranty, infringements of third-party intellectual property, negligence. You know, there are so many different ones, and this clause is messed with so much that all I can suggest and recommend is that if you see an indemnity and a limitation of liability clause that's been a bit messed with, is just to break it up and say, what exactly am I giving an indemnity for? What am I liable for under this contract? Can I get insurance for these additional risks? How much is that insurance going to be? What is the, you know, you have to start asking these questions when you look at your liability umbrella under these contracts. Okay, so always try to limit liability. Oh, and just one more thing as well, is sometimes what they say is that if there's any delay damages or performance damages, those are also excluded from the cap. So it means you'll be contract price plus the indemnified amount plus the 10% cap on delay damages plus 5% cap. So, you know, you can start like really taking your umbrella, and when it used to look like a nice, pretty blue umbrella, now it's looking really black and like funeral-like, because you're now taking on all these risks and all these exposures that you weren't aware of. So be very, very careful when you're looking under your liability umbrella. I've got 2 more minutes. Okay. Then Mish is going to talk about dispute resolution, I think. So I just want to quickly run through delay and disruption to the works. And I think we are aware of this, but just, you know, to refresh our memories. There's 3 basic groups that I like to, you know, when I explain it, to group it into: the events caused by the employer or his other contractors or his engineer or whoever, you know, in his camp, and then you have the contractor that causes the delay, and then you have something else. So the force majeure, the delay of, you know, materials, from, you know, unavailability of materials and goods, the rain, you know, all of those things that can actually delay the works. And these are all dealt with differently under the contracts. So under the JVCC, for example, you have your three abilities to claim. You have your claim for an extension of time with an adjustment to the contract price. Those are 4 events for which no one is responsible. You have employer caused delays, then he gets an adjustment to the contract price, and they like set it up in a nice, neat fashion. In the FIDIC, for example, it's littered all over the place. So 2.1, employer fails to give access. That's an employer delay. He gets time, cost, and profit. Change in law, that's not any of our issue, but you're going to get your time and cost, no profit. So that they all dealt with very differently under the contract. If you start seeing changes to the standard form contracts, for example, I've seen in some of the FedEx, they've deleted all reference to profit, which means that even if the employee is in breach of contract and the contractor has a claim for extension of time due to lack of access, he never actually earns profit on the cost. So little things like that and little nuances, and it all comes down to how we calculate the claim for the entitlement. Once we have our number of days, is how do we calculate the cost associated therewith. And just a hint, clause 8.4 in FDIC, by the way, does not entitle you, the contractors, to cost. I'm still seeing it almost every day in my practice, is that these contractors believe that when they submit an 8.4 claim for an employer delay, that's not referenced in any of the clauses specifically, that they're entitled to their cost. So just be very, very careful. The FDIC does talk about when you get cost and when you don't. Okay. And then obviously under NEC, it's the compensation events clause. So there you get your costs under your shorter schedule of cost components. So yeah, so it's interesting. Each of the contracts have their own claims process. Look out for the timelines, timeframes that have been reduced. Look out for additional time bars that have been added in. They add in this early warning notice into the FDIC. It says that if you don't give an early warning 7 days after the event, then you can never submit a claim for extension of time. I don't know, they do very strange things. So when you're looking at entitlements to claim, employer tries to make it very difficult for the contractor to claim. And contractor must make sure that he understands the steps and procedures. Okay, I always like to say, draw a little picture, draw a timeline. When this event occurs, what do I have to do beforehand, what I have to do after, can I comply with it, etc. Okay, quickly, Mesh, I'm going to eat it to 2 minutes of your discussion, I'm sure you don't mind. It's just in terms of the governing law, people get confused about this as well. What does this mean? Okay, so there's a law of the contract, and then there's a law of the country. Okay, so the law of the country, for example, in FDIC capital C is the law where the works are being executed. Your works need to comply with the law. So it needs to comply. If there's special specifications that need to be had, if you're going to be doing lifting in a mining shaft or whatever it is, you need to make sure that you comply with the law in the country where the works are being executed. The other aspect of the law is how do we interpret the contract? So South African law is different from Namibian law, is different from the law in Germany, is different from the law in Brazil. So that how, when we read the clauses of the contract, are we going to interpret it? So don't be confused. There's two types of law, and they can be different. Works in accordance with the law of the country, and how do we interpret the contract? Okay. So if you ever see the two of them, don't be confused. Okay. And then just obviously the change in law we spoke about earlier. I think this is also quite an important clause because this had an impact. When the government declared the state of disaster, is some of the contracts actually enabled the contractors to claim time and cost as a result of the promulgation of that new legislation. So just in terms of the FDIC, it's already an employee's risk. In terms of clause 13, there is the ability to claim additional time and cost as a result of a change in law. But in NEC, you have to actually add in option X1, should you want that to be applicable. So be careful of that and just understand the ramifications around what happens if there's a law change and it's going to cost me as the contractor extra, or it's going to cost me as the employer extra if I'm agreeing to pay the contractor. So yeah, bit of a shift there in that. And I think the payment provisions, the only thing that I want to say in terms of this clause is what I've seen that causes issues is when people just go and stick in an invoice, a tax invoice clause. They're literally write something that doesn't even speak to the rest of the clauses in the contract, and they say, contractor must provide a tax invoice and then payment will be 30 days from invoice. Okay, so how does that link to the issuing of the certificates? And how do we fit it into the fact that you have to assess my claim within 28 days of the payment claim, issue the certificate? Where's tax invoice like infiltrating into that process? So yeah, be very aware of payment provisions, amendments there too, adding these invoicing provisions without actually considering how they're going to fit. As the contractor, you think you have a 30-day or 45-day payment term, but if you read the provisions of the contract, from the time when you submit your payment claim to certificate to invoice, and then 30 days later, you might be sitting on a 90-day payment term. Okay, so I've seen it almost every day as well in my practice. So please be very aware. Also, rights on late payment. You need to just make sure that all your rights are not taken away as the contractor, that if they don't pay you, you must just carry on working until the cows come home, you know. So there needs to be something, there needs to be some kind of stick that you can hit them with. And yeah, I think Mish, I've taken up. I just wanted to talk about there was just two more. I think you know about the penalties and damages. I think as the contractor, you want to cap them. Make sure that they are actually commensurate to the loss or damage that the employer is going to suffer if he tries to claim them. There's something called the Conventional Penalties Act in South African legislation that actually says that the penalty cannot be out of proportion with the loss or damage actually suffered. So when you thumb suck 0.1% per day, 1% per day, what are we actually doing? Are we actually taking into consideration the actual loss or damage that we're suffering every day that we're late? Because if we aren't, and we aren't actually suffering any loss, the contractor could have a claim to the court to have the penalty reduced. So be a bit more wary of that. If any of you want to ask me questions, please, you're welcome to phone me. I can talk about this all day and I love talking about it. So I think get my cell phone number, give me a call. We can debate any of this stuff. This is my life. So yeah, I'm rushing through it and I apologize, but yeah, you can. And generally the right to set off, employer likes to be able to set off any claims for damages, penalties, etc. There needs to be a claims process for that. So for the FIDIC, in the FIDIC, for example, there's clause 2.5, where the determination needs to be made by the engineer before any amounts can be deducted off the payment certificate. So be very careful of a right to set off. It's a dangerous game you're playing without having the engineer or the principal agent or someone controlling the calculation and deduction of those claims by the employer. And then the termination for convenience. Yeah, so that's supposed to be a no-fault termination. It actually gets used quite often, believe it or not. And there are a lot of fights about this termination for convenience. It's supposed to be a no-fault termination where the employer, for example, decides he no longer wants to carry on with the work, or the project is no longer viable. He then says, look, I'm not carrying on. It means that he's not allowed to give it to someone else because he doesn't like your face. It doesn't mean that he can do it himself. If he thinks he's clever and he wants to know, he'll save some money. It means that the project's been canned. Okay, so it's a no fault. Employers like to change this to say, I'm going to terminate for convenience and then I can employ whoever I like to finish the work. That's rubbish. Okay. And if they want to do that, then they have to give you an incentive as the contractor to make sure you then get a loss of profit or something like that. Okay, and that is my, wow. Time flies when you're having fun. Thank you guys for your for listening. Like I say, please, I'm welcome. You can phone me anytime if you want to discuss anything in a bit more detail. I'm very open to it. Okay, and have a wonderful day. And I'm now handing over to Michelle, and she's going to carry on with her topic.
Naz, if anybody has any questions, quickly.
Okay, we can look quickly. Where can I find the recording? Okay, you can answer that.
Ask your question.
Sorry, on the issue of payment certificates,
Yes.
if the contractor is a VAT vendor, doesn't the employer's obligation to pay the contractor arise only after the contractor has submitted a VAT invoice?
No, well, the obligation would arise under the contract if there was no provision that provided for in the contract that provided for the VAT invoice, right? His obligation for payment would arise under the contract. Whether that's legislatively correct or not, I mean, I can't really tell you, but his obligation would arise under the contract, and that would have had to have been raised during the contract negotiations to say, but I'm not paying you until you give me a VAT invoice. And that's why those clauses are inserted. Okay, for that very reason. However, when they insert them, and that's the point I was trying to make, is that they mess it up and they don't know where to put it into the payment process properly so that it flows smoothly. But that's why it's added, but it's just not added correctly very often. Yeah.
But like an organ of state can't pay without a VAT invoice. That's part of the PFMA or the MFMA.
Yeah, no, fair enough. And I'm saying that's why it's added into the contract.
Okay.
If they didn't add it into the contract and there was payment due on a payment certificate, they would be in breach of that contract if they didn't pay, no matter what the law said. If that makes sense.
Yeah. Okay.
Amish, I don't know if you have any other thoughts on that.
No, I agree with you, Nats. They've got that contractual obligation to pay. Obviously, that's why they are inserting it in, because they've got the legislative obligation to pay on an invoice. As you've been saying, it's all about making sure that it fits correctly into the contract and into the timeframes and the processes that they need to follow. Okay, anything else? Okay, should I start screen sharing then?
Yeah, Mish, you can proceed.
Okay. Can I just confirm that you can see my screen?
Yes, that's perfect. Thank you.
Okay, just going to try and I think that'll do. Okay, so you guys, you've heard from Natalie speaking on her area of expertise. That's the contract drafting side of things. I work on the other end of the contract, so the dispute resolution side. So I've been asked to talk to you about the tiered ADR process that we work with in the various standard form contracts. Okay, so firstly, and I hope I'm not preaching entirely to the choir here. I know we are an adjudication association. I hope there's some of the attendees who aren't actual adjudicators and will benefit from this. But just to start with, what is ADR? So it stands for Alternative Dispute Resolution. What it really means is anything that isn't court proceedings. So it has to be agreed between the parties. So court proceedings apply by law. Anybody can refer a dispute to court proceedings unless they've agreed another alternate dispute resolution mechanism. There's no hard and fast rules on what this dispute resolution mechanism can be, but there are a few resolution mechanisms, and we'll have a look at them, that have been sort of developed and designed, which the parties then everybody understands what they mean and generally what the rules of engagement are, and they can then contractually agree to apply it to disputes if and when they arise, or they could even agree after they arise that they prefer not to take it to litigation, they prefer to take it to adjudication, arbitration, whatever it may be. But knowing what disputing parties are like, once you've already gotten to the dispute stage, you cannot agree on anything. You're fighting tooth and nail over every last full stop and comma. So those kind of processes are best agreed up front, and we see that in the standard form contracts and their dispute resolution sections. Okay, so I've said here there can be any agreed process, a variety or a variation on the processes. And what usually happens, and then what we're talking about today, is that they're tiered. So we'll normally see mediation, adjudication, arbitration, or court. And it'll follow a tiered process throughout the contract. Okay, so it's Tiff, if there are any questions, just let me know. I think I've got it set up a little bit funny. I'm not seeing any, the Q&A box. Okay. Thanks, Tiff. So talking about the commonly used ADR processes, I don't think this is anything of a surprise. I've picked the 4 most commonly used, and that's negotiation, mediation, adjudication, and arbitration. Negotiation is usually slipped in there, let's see, a little more subtly. It's generally just a discussion between the parties aimed at reaching agreement. So note, we're talking about between the parties. There's no third neutral party involved yet. We're just saying the parties will have a discussion about this dispute and see if they can resolve it. So I'll take you through some clauses that have been inserted. The NEC 4 is an example of some of the newer ones where they're starting to use these kind of negotiation clauses. But oftentimes you'll see in the bespoke contracts or the contracts with the special conditions, they'll have a clause saying before you go to whatever your dispute res process is, like adjudication or arbitration, you will refer it to the senior representatives who will meet and discuss. And if they haven't reached a resolution within X number of days, then it will be referred on to the next or the main dispute res process. But that in and of itself is an ADR, an alternative dispute resolution process. It's a process of resolving the dispute alternative to court. And you can have any number of clauses or variations on how you set up that process and how the parties agree it will flow and be governed. Okay, so the next one is mediation. This is a neutral third party. The parties select this person by agreement, Again, you're probably going to be wanting to do it before you get into a dispute situation, because at that point, you're not very good at agreeing with each other. But the parties will agree this neutral third person, and this person will assist them in negotiating their settlement. So notice you've taken one step further. It's not just the parties negotiating amongst themselves now. You've now got an independent third person involved. This person is now assisting the parties, but they're still negotiating. The mediator doesn't make a binding decision. That's not the purpose of mediation. It only becomes binding once the mediator has mediated between the parties have negotiated, they've agreed on terms on which they would be happy to settle. They produce a settlement agreement, they sign it, whatever they need to do to get it agreed. That then becomes binding. There's nothing the mediator can do if the parties do not agree to render some sort of binding decision. So you'll notice in the contract provisions, this is usually sort of a preliminary step before one or two further ADR procedures. Alternatively, it sort of runs parallel or to the side of the main ADR procedures, and the parties can usually get a mediator involved at any time. What is important to remember, both with negotiation and mediation, is that actually at any time, no matter what your contract says, the parties can pull back and they can say, hang on, we don't want to waste money. Let's negotiate. Let's agree. This is the process we're going to follow to try and negotiate and agree. And when they reach, or if they reach that settlement, that is binding. And they can do that at any time, regardless of the ADR procedure stipulated in the contract. Okay, so next up is adjudication. Again, we've got a neutral third party, or this time we might have a panel of neutral third parties that the parties are using to assist them in resolving their dispute. But we've now taken another step forward. It's not the parties negotiating. They're beyond that point. They cannot agree with each other. They're now getting someone who's going to be making a binding decision for them. He's not just there to facilitate their discussions and tell them, you know, where they're being a little bit unreasonable and suggest they make compromises. He's there to listen to both sides. He has his inquisitorial authority, where he can ask questions, he can request further documents, and then he makes a binding decision. Normally, and this is how we understand adjudication, temporarily binding, unless or until it's overturned by, usually be court or arbitration, it's usually arbitration. And most of the contracts, they'll have a period where the party who lost the adjudication, or whichever party is dissatisfied with a portion of the adjudicator's decision, can notify a dispute. And if they don't, it becomes finally binding. And the reason it becomes finally binding is because the parties have agreed to that. So you can actually enforce the adjudicator's decision because you've contractually agreed to do so. If you went to court, you'd be asking the court to order the other party to comply with their obligations in terms of the contract, which is a little bit different than if you went through the courts purely through the litigation procedures and said, this person owes me a debt. I want the court to declare that they owe me that debt. What you're actually doing is you're going through the court and saying, this person has agreed to abide by a decision by an independent third party who we call the adjudicator, and they're refusing to abide. I want the court to order them to comply with their contractual obligations. Okay. So an adjudicator can be standing or ad hoc. For those of you that don't know, so standing will be, generally they'll be appointed one person or three-person panel is the usual at the beginning of the contract. So they will usually have additional responsibilities as a standing adjudicator or adjudication board, where they'll come to site every so often and they'll have a certain number of site visits, or they'll review progress reports or meeting minutes or whatever it may be, and keep themselves au fait or familiar with what is going on site. And they're meant to be there as a sort of preventative measure. So there should be, in the provisions on how the standing board can operate, a provision that says, look, we've got the standing adjudication board. We'd like to be able to ask their opinion on something or bounce something off them. And the provisions of how your adjudication procedure governs that process should ideally allow the parties to do that and him to come back with some sort of opinion, even if it is not a full-blown dispute that he's making a binding decision on. He gets to say to them, look, if you were to refer this dispute to me and you spent a lot of money drafting papers, maybe you got some external legal advice, I would probably give you this opinion. It's not binding right now, but if you made the submissions to me in the proper adjudication process, then this would be my decision unless there's something else that I haven't seen that would change my mind. So you'll see that kind of process set out in the, let's say, the special conditions for the SANRAL contracts, where they've taken the normal FIDIC adjudication board where a dispute is referred to the adjudication board and they make a decision, and they've inserted a provision saying that the parties, if they jointly agree, can ask the DAB to make provide an opinion. And it's not binding. He might change his mind if they refer to him as a dispute and give him a reason to change his mind, whether they change the clauses they rely on, produce additional documentation, but he can make a preliminary or give a preliminary opinion, which might cause the parties to say, oh, no, we're not even going to bother to take it to dispute. It's a waste of time and money. Let's just carry on the basis of this opinion. We also have the other side of the adjudication where it's ad hoc, and that's an adjudicator who would be appointed as and when the dispute arises. And the advantage of that, you're obviously not paying a retainer fee to an adjudicator or adjudication board who's retained on the project, and not necessarily dealing with disputes if the parties aren't very adversarial. And this person will then, it doesn't have to be the same person for each dispute. So if your dispute on one aspect is a legal dispute, you might want an advocate, a senior counsel to decide your dispute. Whereas another dispute may be quantum-based, you may want a QS to decide your dispute. So the advantage of having the ad hoc adjudication is that you can choose the expertise of your adjudicator. The disadvantage is that they're not already familiar with what is going on site, how the parties operate, and they haven't already established a relationship and a understanding between the parties and the DAB of how rulings will go and how various submissions and thoughts are considered and understood. Okay, and there's also something else that we need to consider, and you'll see it reflected in the dispute res clauses that I'm going to take you through for the various standard form contracts, that you have different types of boards that you're now starting to see in the various standard form contracts. So I pulled out dispute adjudication board, which essentially is a board of adjudicators who adjudicate disputes. It's another way of describing the adjudicator. You'll see under the GCC or FIDIC, they'll be referred to as the adjudication board or the dispute adjudication board, the DAB. It can be one person who is that board, or it can be 3 people who is that board. But that's the purpose of the board, is to adjudicate the dispute. Whereas what we have developed, which is a little bit different, you'll see it in the FIDIC 2017, I've just looked at the red book, is the dispute avoidance board. Now that's a board that is used just to provide recommendations or opinions. They don't go ahead and make a binding or temporarily binding adjudication decision afterwards. They make a recommendation. And then we have the DAAB, the Dispute Adjudication and Avoidance Board. That's the same board. So it's constituted of the same 1 or 3 members, whoever they may be. And they can first be appealed to, as we discussed with the SANRAL particular conditions, for an opinion. And if the parties don't want to comply with that opinion or feel they can change the DAAB's mind, they'll then make further submissions to them as the adjudication body, and they'll then render an adjudication decision. So it's important to just understand the difference between the adjudication board, the avoidance board, and the adjudication and avoidance board. And it's very much the same functions. One's a determination, which is temporarily binding. One's a recommendation, which is not binding. And the third one is just a combination of the two, and they serve both purposes, or they wear both hats. Okay, just checking the time. Arbitration. Again, we've got our neutral third party or parties. We've got our board. It's usually 1 or 3 people. We select them and they determine the dispute. This time, it's a binding decision. Sometimes, depending on what rules the parties agree to govern their arbitration, there might be an appeal. So you'd have an arbitration and then an appeal from that decision to another arbitrator or panel of arbitrators. I've very seldom seen that happen. Most parties want arbitration to be the end of it, well, the first arbitration to be the end of it, because they have already followed their tiered process of amicable settlement or negotiation or mediation and then adjudication and then arbitration. They don't want to have another procedure to follow thereafter. But it is available depending on which rules that you're following. But this process is usually the final one. The parties normally choose between arbitration or court. It's not normally arbitration then court. It's that arbitration, if you've chosen arbitration as your alternate dispute resolution to court, is usually the final port of call. And you'll see there I've said the Arbitration Act and the International Arbitration Act apply, depending on if it's local or if it's international, which is very different from the other alternative dispute resolution mechanisms we've discussed. They don't have any legislation governing them. They're everything in those dispute resolution mechanisms, so negotiation, mediation, adjudication, is all done contractually. The processes you follow all have to be agreed between the parties in order for them to apply, and they all have to function. If you don't have a functioning agreement, you can't enforce that agreement. So it's a very good idea when drafting your contract to make sure you have things completed, like if you've got to have a adjudicator, are they appointed in the contract or will somebody appoint them? Who's going to appoint them? If we're not going to be able to agree that as parties between ourselves, we need a nominating body. If we have to have that nominating body named in our contract, because at a later stage, if we try to enforce this provision and the nominating body isn't named, and parties can't agree on the adjudicator, we're not going to have an enforceable provision because we have no mechanism to enforce the appointment of the adjudicator. Similarly with the rules. So in our adjudication agreement that we've hopefully concluded at the commencement of the contract or prior to the commencement of the contract, we should have stipulated these are the rules that the adjudication will follow. This is the submission. We have 2 weeks to make a submission. The other party has 2 weeks to respond. These are the powers of the adjudicator. The adjudicator only has the powers that are conferred on him by the agreement between the parties. Things like the adjudicator's jurisdiction. Generally, an adjudicator doesn't make a binding decision on his jurisdiction, but he will make a preliminary decision to say, look, I think I can go ahead. I think I've got the right to hear this. Or he'll say, no, actually, I don't think I've got the right to hear this. I withdraw or I resign as adjudicator. The parties may say, but we want him to be able to make a temporarily binding decision on his jurisdiction, and they will insert that into the adjudication rules, which they've agreed up front. If there's no rules governing how the adjudication will operate and nothing to say that the adjudicator can impose those rules on the parties, you're not going to have a functioning adjudication clause. Okay, so that's very different from arbitration, where if the parties haven't agreed a different procedure or set of rules, they can fall back on the Arbitration Act, which is always present and available to them. But just because the Arbitration Act exists doesn't mean that you automatically have a right to go to arbitration. That's not the case. The parties still have to agree in their contract or in some other form that they can refer that particular dispute or any number of disputes to arbitration. And once they make that agreement, then the Arbitration Act will apply where they haven't agreed alternative rules. Okay. So then just having a look at the standard forms of contract. So I've gone through all 4 main standard forms plus the NEC 4 and the FIDIC 2017 just to get a different variation on the different tiers or types of ADR processes that are being incorporated into our contracts. So if we have a look at the GCC 2015, we've got that clause 10.4, amicable settlement, and you'll see they say it can happen at any time. So in some of the other contracts that we're going to look at, that amicable settlement process is only triggered after, let's say, adjudication has happened. Whereas under the GCC, they say you can trigger this and there's a process to trigger it at any time. So they're adding a little bit of structure to their amicable settlement, which is not stated to be mediation, but they're saying it's with the help of an impartial third party, and the parties can then agree any settlement technique they want to. You'll notice that if they don't agree a settlement, it's not binding. It's not an adjudication or an arbitration. It's more along the lines of the mediation process with a little bit of negotiation thrown in, but that they can initiate at any time. They've added a little bit of structure to how you would deal with, just the parties getting together and saying, can we sort this out without spending any further money or wasting any further time? If that is not resolved, they refer a dispute to adjudication. Here we can have, and the rules provide for it, standing or ad hoc adjudication. And you'll see that there's an adjudication board rules. I've noticed that some of my clients don't pick it up. The GCC actually has at the back, after clause 10, one of the annexes, they have the adjudication board rules, which apply to any adjudication in terms of their clause 10 adjudication. It's quite important to know that. But you'll see that's going back to my point of, if you have an adjudication provision that allows you to go to adjudication, you need to have a set of rules agreed about the manner in which you will conduct that adjudication and what the powers of the adjudicator will be. Otherwise, you're not going to have an enforceable adjudication clause. Okay, so once you've gone to adjudication, if the parties aren't happy or one of the parties isn't happy with the adjudicator's decision, they'll issue a notice of dissatisfaction, and then the GCC allows either arbitration as your last port of call or court as your last port of call. Now, the parties are meant to make an election. If they don't make an election, I can't recall which one offhand, one or other of those is deemed to apply, and it's stated as such in the contract provisions. What it also does state is that the Association of Arbitrators rules apply to the arbitration. So those rules will take precedence over the procedure set out in the Act, and the Act will fill in any gaps that aren't governed by the rules. Okay, so just having a look at the FIDIC Red Book, 1999, we've got our clause 20.4. Here we've got a dispute adjudication board. And that is adjudication. It is adjudication by a board. And they've also, and a lot of people miss this one as well, got procedural rules for that board attached as an appendix to the FIDIC document. After the end of all the clauses, after clause 20, there's an appendix with procedural rules for that board to use and to follow. Then, so as opposed to how the GCC works, where you've got adjudication, arbitration, or court, and alongside it, or parallel to it, you've got amicable settlement at any time. The FIDIC stipulates where after the adjudication, where one of the parties has issued a notice of dissatisfaction with that DAAB's decision, then the parties shall, so shall means they have to, attempt to settle the dispute amicably before the commencement of the arbitration. So this amicable settlement process is inserted in there. Nothing is stipulated about how the process will be followed. Will they meet and negotiate? Will they pull in an independent third party? Do they have meetings? Nothing like that is stipulated there. It just says they shall attempt amicable settlement. And if they haven't reached amicable settlement after, and if I recall correctly, it's 56 days, then either party may refer it to arbitration regardless. But they do have that period where they are required to attempt that amicable settlement. And then we have clause 20.6, which has arbitration and the International Chamber of Commerce's arbitration rules. As a general rule, we changed that to something local in the more local projects, just to limit the costs involved in proceeding to arbitration under FIDIC. Okay, so having a look at how this has changed in the 2017 version, you see we, instead of just a DAB, not just a dispute adjudication board, we've now got a DAAB, a dispute adjudication and avoidance board. So what the parties can do is, before they go to adjudication, they can jointly, so they not only, it's not, what does not permit one party to engage with the board. One party can't run off and have private conversations with the board. The parties must jointly approach the DAAB and request assistance or advice. This is envisioning that the DAAB is actually standing, so they're on site, they're aware of what's going on, they're reviewing the progress reports, they're attending the meetings and so on. And the parties can agree amongst themselves, we don't quite want to take this to dispute yet, let's ask the DAAB how they would deal with this. If we're not happy with it, it's not binding on us, then we'll make proper submissions, pull all our documents together, get our quantifications and so on and so forth, and submit it to them to see if we can change their mind on that advice. But let's get a quick high-level advice to see if we can avoid actually taking it to dispute. So that's the purpose of the DAAB. If the parties don't agree, or one of the parties doesn't agree with that advice, they then refer it to the DAAB wearing its other hat. So it takes off its avoidance hat, puts on its adjudication hat, and they now say, we want an adjudication decision which will be temporarily binding and enforceable through the courts as through specific performance requirements in the contract. And then we have the DAAB procedural rules, which are also an appendix to the 2017 document. And then similarly to 1999, after we've got the DAAB's decision, if a notice of dissatisfaction is issued with that decision, we have that amicable settlement provision where the parties shall attempt amicable settlement. This time, I think it's only for 28 days. If they don't achieve amicable settlement during that period, either party may refer to arbitration. And then you have clause 21.6 arbitration. ICC rules apply here, unless changed by the parties by agreement prior to commencement. Okay, so just looking at the JBCC, I've looked at the 6.2 edition. So this is tiered in a similar manner, but slightly differently. So it starts off with negotiation. It says in clause 30.1, the parties shall attempt to resolve the disagreement. It's not even a dispute yet. One party notifies the other, we have a disagreement, let's attempt to resolve it. And if they do resolve it, they're recorded in writing and it becomes binding. So that's pure negotiation ADR process. If after, I think it's 10 days, they haven't managed to settle it, then the unhappy party, it becomes deemed a dispute and the unhappy party can refer to adjudication. So here it says the rules are stated in the contract data agreed by the parties and adjudicator or determined by the adjudicator, which is great, because if the rules aren't stated in the contract data, and if the parties, because they're locked in an aggressive battle, cannot agree on any rules for this adjudication to be followed, the adjudicator has the authority to determine it himself. So the parties aren't going to lose their right to go to adjudication because they don't have any rules agreed. The adjudicator has the power to dictate to the parties what the rules are. And they're probably going to be, about submissions. You will submit by X date, there will be a replying document. You may respond to that. I will have a hearing. I'll make my decision within X days. Those kind of rules, procedural rules. Okay, if the parties get that decision and they're not happy with it, or under the JBCC, if they don't make a referral to adjudication within a certain period of time, I believe it's another 10 days, they lose their entitlement to go to adjudication and they skip directly to arbitration. So you notice there's a little bit of a time bar, and there's a fast track in the dispute res tiered process. If the parties aren't quick enough to apply the adjudication and you skip the adjudication, you can go to arbitration, or once you've had the adjudication, you're not happy, you can then proceed to arbitration, as you usually did in the other contracts. And again, it says rules stated in the contract data, agreed by the parties and the arbitrator or determined by the arbitrator. It gives the arbitrator that authority. And remember, with arbitration, you have the Arbitration Act in the background, filling in the gaps. And in the JBCC, much like the GCC, you have mediation on the side. So you're busy with your adjudication, your settlement negotiations, your adjudication, your arbitration, and along the side, at any time, clause 30.8 says, by agreement. Unfortunately, parties who are fighting with each other will have to agree. There's no automatic trigger, but they'll have to agree. They can take it to mediation at any time, and the mediation and the procedure will be agreed between the parties. Then we have a look at the NEC3. We go to clause option W1.1 to 1.3. Adjudication applies. The procedure is actually set out in that clause of how the adjudication works. There's no additional procedural document attached as an annexure. Then, if one of the parties is dissatisfied with that adjudicator's decision, they'll notify a dispute or dissatisfaction with that decision. It'll go to what the NEC3 refers to as the tribunal. Normally, it's arbitration. That will be named in the contract data. Occasionally, it's named as legal proceedings or court proceedings. If, and the clause W1.4 says, if it's named as arbitration, then the rules to be followed must be stated in the contract data. And remember, if there's no rules, we've got the Arbitration Act in place. Okay, so interestingly, the NEC4 has made a bit of a change to that. So now when the parties are negotiating their contract, before the signature, they have to choose. They now have a choice between, well, there's options W1, 2, and 3 in both the NEC3 and the NEC4. 2 doesn't apply. It applies to the UK, where they've got the UK Housing and Grants Act, which is a legislative entitlement to refer to adjudication, which we don't have here. Here we have to have a contractual agreement that it can be referred to adjudication. So under the NEC3, we could only use option W1 for our dispute resolution, even though we had to select it and insert it in the contract. Whereas under the NEC4, we now have 2 options, option W1 and option W3, and we select one of those before we sign the contract. So option W1 is very much as the NEC3 option W1, but there's an additional clause, so there's additional tiered ADR step that's been added in. So the first step that's been added in is reference to the senior representatives. And there's a submission document that meant to be submitted, and the parties meet or whatever it is that they want to do. And there's a certain period of time for them to do it in. So you'll notice that is negotiation. It's between the parties. There's no independent third party, but it's been mandated as a step in the ADR tiered process that you're going to be following under option W1. If that doesn't work, then the dispute can be referred to adjudication. The procedure for that adjudication is set out in the clause. And if a party notifies dissatisfaction with the adjudicator's award, it goes to the tribunal, which, as with the NEC3, is generally called to arbitration. If it's arbitration, the rules have to be selected in the contract data. Or, so if the parties say, no, we don't want to do that. We don't want to do W1. We want to do W3. This gives us the option of the dispute avoidance board. Remember, not a dispute adjudication board, that's different. It's a dispute avoidance board who should be reviewing progress meeting minutes, should be keeping au fait or familiar with what is going on site. And they can then be asked by both parties. Remember, again, parties can't communicate with them privately. That's a bit of a no-no in this process. Can ask the avoidance board to make a recommendation, which they can do. A recommendation is not binding. The parties are not obliged to comply with it. It just gives them a general idea of how this independent, neutral person who they consider to be sensible and knowledgeable would handle the matter. And it's a bit of a sanity check, and inserts a bit of reason into the dispute between the parties. If they're not, or the disputing party is not happy with their recommendation, it goes straight to the tribunal. So that's called to arbitration, procedure set out in the contract data. What that does, though, is that it removes that additional layer that usually a contractor would have in place, where they have a binding adjudicator's decision that they can enforce and that they sit with the money unless or until it's overturned by arbitration. Whereas under this option W3, they don't have the advantage of getting that temporarily binding decision. The recommendation is not binding. The recommendation is not going to allow them to enforce payment and sit with the money while the arbitrator, the tribunal, so usually arbitration, is going on and a final decision is being made. Okay, that is my last slide. Does anybody have any questions? No? Beth?
I see we have a raised hand. Yes, if you'd like to pose your question.
Thank you very much. I just need to ask, with this arbitration procedure, it will still, I know it will still be within, it cannot override current laws. So it must still recognize the current law within its adjudication process.
Yes,
What
so
I need to ask is that if there are people that are not registered as an adjudicator or facilitator for adjudication or arbitration, in what capacity is a person allowed then to adjudicate a settlement?
okay, so we need to differentiate between negotiate a settlement. So if we had someone involved there, that would more be a mediator. They would come and sit with the parties and engage with either side and attempt to get them to reach agreement. Whereas we'd have an adjudicator or an arbitrator who wouldn't negotiate a settlement, he'd render a decision, binding temporarily or finally. So that person actually doesn't have to have a qualification. They don't have to be registered with a body. The parties can agree on anybody to be their arbitrator or adjudicator. They just would not necessarily be very wise to select somebody that doesn't have accreditation.
And that I agree with totally. So if you have such a process that is running, you can at any time walk away without being held liable for costs or cost outcomes that might be detrimental to the original agreement. Let's say we've already started the project, we're running it, then we get the problems. Now it goes through this adjudication type of process. But one party then walks out. Can they do in the absence of the other party? Can they do some agreements?
Okay, so remember, it's not agreement. In the adjudication process, the parties aren't agreeing. The adjudicator is rendering a decision. It's a little bit of a lacuna. Rules like the GCC rules make provision for the adjudicator to proceed. So essentially, it depends on what your rules in your contract say. Because remember, the whole process of adjudication is all contractually agreed. So how it runs, what the adjudicator's powers are all agreed in the contract. So up front, as an example, in the GCC, in their adjudication board rules, the parties have agreed up front. If one or other of the parties declines to participate, the adjudicator is authorized to proceed. Look, you may have an adjudicator who's a bit reluctant to do so because as soon as he renders a decision, the enforceability is going to be challenged and he's going to have his name cited in court papers. But that power is being afforded to him by agreement of the parties, and they will, if they're wise, agree that up front rather than try and get it agreed once they're in the heat of a dispute, because they're unlikely to be able to agree on anything.
Appreciate it.
Okay.
Hand raised, Barry, I'm allowing you to speak.
Thank you so much, and good morning, Michelle Kerr. Thank you, very informative presentation. Just a very quick question. I know we've covered the GCC, FIDIC, JBCC, and NEC. Why are we not covering the MBSA documents, which are the contractual documents used by master builders, predominantly for NHBRC, new homes and refurbishment building? They do have arbitration clauses and adjudication clauses. And I'm wondering why MBSA is not featured in your presentation.
I chose the 4 standard forms. I'll be honest, I don't work with the MBSA very often. It's, if I recall correctly, from past usage, it largely reflects what was in the JBCC. I'm not sure about what it looks like now in the later revisions and the updates. It was purely just a demonstrative exercise. I wasn't trying to make it exhaustive. There was no particular reason I excluded the MBSA.
Thank you for that.
Anybody else?
Ask your question.
Hi. Yes, I just have 2 or 3 quick questions. If a contract does not have rules or a clause for adjudication, are parties still free to decide to proceed to adjudication?
Yes, they are, but they would obviously be wise to reduce it to writing. So it would almost be dealt with as an amendment to the contract. So they'd make an amendment, they'd insert an adjudication clause, sign it, both parties, and obviously they'd agree a process for that adjudication. So they'd make sure you're not just saying, we agree we can go to adjudication. You're saying, we agree that we can go to adjudication in terms of these rules. This is our adjudicator, or this is the body that can nominate an adjudicator if we cannot agree. But yes, they can do it by agreement after the fact. Okay, perfect. Then another one, is there any guideline or procedures for the conduction of adjudication? Like if they want to add this addendum to the contract, can they make up their own rules, or is there sort of a guideline to use or a document? Or if I were going to be drafting that, I'd have a look. Well, there's very similar procedures and rules that are followed in most of the adjudication processes. So it talks about exchange of documents, it talks about the powers of the adjudicator, it talks about ability to call a hearing. The CIDB has a set of adjudication rules, if I remember correctly. Way back in the day, they were being used with the GCC 2004. But if I were drafting that, I would be using the sort of the stock standard understood procedures and allowances that we would normally make for the rules. But if someone who is not a person who deals with this all the time, so you're not familiar with what those are, I would suggest you have a look at the rules and the standard forms, just to get an understanding of what's normally required and sort of follow that process. Okay, great. Then if
CAASA have also developed a set of adjudicator rules which are available on the website.
Okay, perfect. Thanks for that. Then if no contract is signed, let's say, for instance, it's an informal, someone knows, a client knows a builder and they just sign on a quotation, and obviously it's a lot of risk involved in that. And then at some point they dispute and say, yeah, but you didn't include the roof cost or whatever the dispute is. And they call for adjudication or they sign an addendum. What basis does the adjudicator have to say, okay, the contract says you should have submitted this and this, but there's no contract in place? Is it wise to go to adjudication, or is that purely then a legal matter that needs to be sorted out?
Well, look, okay, if you can get to agree that adjudication applies, hopefully reduce it to writing this time and have it signed, you can then choose who your adjudicator is going to be. So if you've got an argument like that, you'll be relying on the common law, you'll be relying on provisions of an oral contract, it'll be evidence, which is a little bit more difficult under adjudication, which doesn't really envisage lengthy, giving of evidence by witnesses, but it can be done. you'd probably want to say, well, we want an advocate or a senior counsel as our adjudicator, because they're going to understand how to interpret the common law, how to figure out what the clauses of an oral contract are, how to consider the evidence of the witnesses, you know, what is credible, what isn't. And you'd use that ability to select the qualifications of your adjudicator to your advantage.
Okay, good. Thanks for that. And then the last question was based on more for CAASA. I recently joined as a member, but I just want to find out, how does one get selected on a panel to get recommended on future or dispute adjudication recommendations?
So Tiffany's going to answer you there. She's the secretary.
Yeah, well, if you go to our website, adjudicators.co.za, there is a application that you can complete to apply to become a panel member. That's then sent to our sort of panel exco members, where they assess it, and then yeah, you'll either be accepted or there'll be feedbacks supplied.
Okay, great. Thanks for that.
No problem.
Thanks, Evel.
Yeah, if you're ready.
Any other questions?
I know, but we're going to meet at 12. And I was going to half an hour.
Just muting some people here. No, thanks, Mish. I'm just looking at the Q&A box, but those look more like some comments, and I think we've covered everything.
Okay. Okay, perfect. Thank you, everybody, for attending. Much appreciated. We hope you enjoy it, and we hope to see you at the next session.
Thanks, everyone. Have a good day. Enjoy the rugby tomorrow.